Hi drivers, Paul Taylor here from Truckers Justice Center. Truckers Justice Center is a law firm, small law firm located in Minneapolis, Minnesota, but we represent drivers in federal court and federal agency matters around the country in employment-related cases. I want to talk to you about the STAA, and if you've watched these videos in the past, and you can or go ahead and watch more of these, you'll learn a lot about the STAA. Stands for Surface Transportation Assistance Act. It essentially prohibits a trucking company or a private carrier, if you're driving for a private carrier, private entity that operates trucks with a gross vehicle weight rating of 10,001 pounds or more on the highways, you're protected by the STAA. Essentially, the STAA protects you from retaliation for complaining to the employer or the government about violations of commercial vehicle safety regulations, and it protects you from retaliation for refusing to drive because driving would result in an actual violation of a commercial vehicle safety regulation. It also protects you from retaliation if you refuse to drive because you have an objectively reasonable belief that operation of a truck would be unsafe. You are also protected. So let's talk about the actual violation clause of the STAA. No person shall discharge, discriminate against, and discipline an employee, which can include an owner-operator when personally operating the truck, because that driver refuses to drive because driving would result in an actual violation of a commercial vehicle safety regulation. Well, it doesn't say that the truck's got to be unsafe. The law says that you are protected when you refuse to drive because driving would violate a commercial vehicle safety regulation. So, for example, we have regulations dealing with equipment. 392.7, 49 CFR 392.7 says essentially no driver shall operate a commercial vehicle unless he has assured himself that the following parts and accessories are in safe operating condition, or good working order, excuse me. That's technically what 392.7 says. And it includes among those parts windshield wipers and defrosters. Now, if it's 95 degrees out and sunny and no forecast of rain, it's not unsafe to operate a truck without defrosters. It's not unsafe to operate a truck without working windshield wipers. But the regulation says you shall not operate unless you've assured yourself that certain parts and accessories are in safe operating condition. Just like it might be perfectly safe to operate 2 minutes past the 14th hour of first going on duty and thus be protected under the hours of service rule, could be perfectly safe to do something. But as long as you are refusing to drive because a commercial vehicle because driving would result in an actual violation of a commercial vehicle safety regulation, you are protected under the law. Now, I'm not advocating rubbing the employer's nose in something that's illegal or unlawful, but still nonetheless safe. But we have a set of regulations set up by FMCSA under the authority of Congress to set the minimum standards for safety. And rather than lowering those standards or going below those standards, we should be elevating them, and drivers should be striving to make sure their vehicles comply with commercial vehicle safety regulations. Because it may be perfectly legal to drive today when it's not raining, snowing, there's no forecast of rain, and you don't need defrosters or windshield wipers. But carriers should be keeping their equipment compliant with commercial vehicle safety regulations. Thanks for watching.